So here we are at number 4 of our training seminar. We last left off, we were talking about the premises liability case, which is Redder versus Recovery Physical Therapy, and we talked about how we set up a plan and how we set up our quadrants. And today we're going to, I mentioned earlier that we're going to be doing what this profession's version of dissecting a frog is. We're going to look at a deposition, and you have it all before you in the form of a slideshow, and we're going to go page by page. And it's not to ridicule the questioning attorney, and I crossed out the names of everything so you can't see who it is, and you don't know who it is, but it doesn't matter. What matters is that you see this and you understand it as a casualty, and that you don't let it happen to your associates or to your colleagues if you can prevent that from happening. And the number one, this will not happen to anyone who has been with us for the first 3 installments. This will not, because you know that you have to have a plan, and you know how to set up a plan. This is a deposition where the questioning attorney did not have a plan, and there was absolutely no preparation. And as we go through it, I want you to pay attention to the phrasing and think about whether or not you would object to the form of the question. I mean, of course, you're not going to have to say it, but I just want you to recognize and get used to recognizing problematic questions, ones that are defective legally. And what I mean by defective is that there's a form problem with the question. And I was speaking to Stacy after one of our sessions, and she said, you say objection to form, and then you allow the witness to answer the question. So if all you say is objection to form, then why do you have to know the Marvel Act's objections? And you remember that's the mnemonic for multiple, assumes fact not in question, repetitive, V vague, I is irrelevant, L is for leading, A argumentative, C confusing, and S speculative. Why do you have to know those? And I said, I really didn't explain that, did I? And here's the reason. So let's say you're asking a question, and the question is, so you went to the intersection and the light was red. And opposing counsel says objection to form. And that's all they really have to do, and then the question is objected to, and you will not be able to use that at trial. But suppose you want to use the information that you just received, and you're not sure what the basis of the objection is. You know that it's just form, and form is all of those things in the Marvel Acts and others, that come under that definition. So what you have to do is if you're not sure what the problem is, and you want it, just try to rephrase it into another form that would be okay. So let's say you want to find out exactly what the problem is. What you do is, okay, here's the question. You came to the intersection and the light was red, correct? And objection to form, they answer over the objection. They say yes. And so what the next move is, you say, well, counsel, what's the basis for your objection? And they say, well, I said form. Yeah, but what's the specific legal objection? The correct answer, of course, is leading. Okay? And at that point, you're aware to say, okay, so now let me ask a non-leading question. What color was the light when you arrived at the intersection? There you go. That's the end. Now you turned it into an open-ended question. There's no objection to it. Now you get the information. But suppose the opposing counsel does not know the specific objection. Well, then you know what? There's a good chance that you'll be able to use that information at trial because you were not given an opportunity to correct it. That's why you have to know the Marvel Acts. That's why you have to, and you're gonna see in this dead frog here, you're gonna see how these objections work. And I'll just tell you right now that the entire deposition is 15 pages long. And there are no objections. And that is another thing we talked about. What are the metrics? What do you gain? What do you lose when you make an objection? And you're going to see here that you didn't really need, if you're defending the deposition, you didn't need to object to anything, even though just about every question was objectionable. Before we get into it, and we're going to get into it in a minute, I do want to talk about a couple of basic rules when you're conducting the deposition and things to keep in mind. What you're hoping to do is to have each question and answer self-contained. So you don't have to make reference to other portions of the transcript to explain who you're talking about. And a good way of doing that is to just take pronouns and throw them into the garbage. Do not use they, them, he, or she in a question by itself, so that you have to say later on who's he, who's she, who's they, who's them. You should just try to get out of the habit of using that. So, you know, in each question, if you just take it by itself, you know exactly who you're talking to. So self-containment in each question is something that you keep in mind. You know, you're going to see the questioning attorney in this case did not give a real good introduction. And that's, I get that. Some people stylistically, they don't even, introduce themselves. They just get right into the questioning and that's it. That's stylistic. I get that. But especially when you're starting out, I still do it most of the time. I do my litany of questions just to get things rolling. Good morning. My name is Joe Nohavicka. I represent, excuse me, I represent the defendant in this case, and I'm going to be asking you a series of questions related to a lawsuit involving here, recovery, physical therapy. If I ask you a question that you don't understand, just let me know and I'll try to rephrase it into a form that you do. Okay? Are we agreeable with that? And they'll say, yeah, sure, whatever. And if I ask you a question that you don't hear, let me know and I'll either repeat it or I'll have the court reporter read it back to you. And that's another thing we didn't talk about. You can have your court reporter read back a question if you don't feel like repeating it or you can't remember. And just say, you just stop and, you know, the witness says, I didn't hear the question. And just say, will the court reporter please read the question back? Everything stops, they go through their notes and they go over the question again. And that's how that's done. That does not happen in court unless it's a very rare occasion and you have to ask the judge for permission to do that. So in the middle of questioning, if the witness says at trial, the witness says I didn't hear that or I don't understand the question, you can't tell the court reporter to read it back. You might see it once in a while. It's improper, and the only reason it's allowed in any situation is because the judge doesn't know that it's not permissible. You have to stop the trial at all. You have to have permission from the judge. So continue on with the introduction. And we went over this before when we started, but I want you to get used to doing it, and I want you to find your own voice when you're conducting these depositions because it has to come off naturally. You should start doing it by memorizing something, so you have coming out of the gate. Everybody sees that you have control and that you know what you're doing. So I will say, please allow me to finish the entire question before you respond, because as you can see, the court reporter here is taking everything down. And we want there to be a complete record. When we read the transcript, we want to have a full question followed by your complete answer. Do you understand that? And they'll say yes, and then you continue on. And then you say something like, if you need a break for any reason, just let us know and we'll take a break, okay? And they say, yeah, I say, okay, let's begin. One of the things, if I could just recommend something, even for our seasoned attorneys, some of them do, and again, this is a stylistic thing. A lot of them like to explain that the witness shouldn't guess, and I understand why they want facts. You know, that's what you're there to get facts. But you know, as you know from the Marvel Act's objections, the S stands for speculation, so it's a form objection. You know, so it anticipates that question could be asked. But it also anticipates, since it's a form objection, that it can be answered. And that could lead you sometimes to good information. So if you're asking someone that says, well, I don't, they answer the question, I don't know. And then you say, well, speculate. Who do you think might know the answer to this question? And you know what? That's a guess, because they're guessing right there. So their attorney could object and say, you told them at the beginning that you didn't want them to guess, and they'd be absolutely correct. And you'd have to correct yourself and say, look, you'd be in an awkward position to explain why you need an answer to the question. So I avoid I avoid saying don't guess to any of my questions. I just want to make it clear in the record, though, that they're not answering based on actual knowledge, but they are guessing. So that I say, take a guess as to whom I know, and they name a couple of people off, and I might get a hit on one of those. So that's why I don't ask that question. So anyway, that's just a stylistic thing. I don't do it. I recommend that you don't. But again, that's up to you. So let's get into the depo. Just keep in mind the objections. Okay, so if you are all on at the top of the page on the slide is 282, and then on the right there's a number 5, and we have the name Robert, and you see the numbers. Those are the lines, of course. And if you're making reference to this during trial, you say, I refer you to page 5 of the deposition. Line, for example, line 8, where the questioning begins. So that's how you make reference to it. So you see that the witness here has been sworn in through lines 2 and 5. And then we have the examination by the questioning attorney. Okay, and they start with, please state your name for the record, and there's an answer to the name, and where do you reside? Now, I'll tell you and I spoke about this when we first started. The attorneys don't actually ask those questions while the court reporter is setting up. They're swearing the witness in, and they're getting the first 2 questions on, and that's when you ask, or you direct the court reporters, please, swear the witness in, get the first 2 on, and just give me the green light when you're all ready to begin. And that's when you get into your introduction. So here we have the attorney's 2 questions are on, and his first question is, where do you? His first statement is at line 14, and he says, "Good afternoon," and says who he is, and I'm the plaintiff's attorney. I represent Mr. Singh in this action against Citibank. And he gives kind of an introduction saying, I'm going to be asking questions about Citibank's relationship to the bank in question. So right out of the gate, he's asking a witness, he's telling him about a relationship, which is a problematic word in and of itself. And if you have a well-prepped witness and you're a brand new attorney, you're just new to questioning, the witness may try to trip you up by saying, what do you mean by relationship? Or any word that you use. And you have to be ready for that, because they're going to try to bully you in the beginning if they see that you can be bullied. And the way you respond to that is that, you have a couple of ways to go from that. You can ask whether they have ever used that word before. Or is this a word that you're not familiar with in usage of any kind? You could have your phone dictionary, your phone dictionary, or an actual pocket dictionary. If you're anticipating this kind of questioning, in the old days, we used to just have a little pocket dictionary, because I used to get these questions all the time, or responses all the time. And I would look up the word, and I would say, Webster's, desk dictionary defines relationship as. Can we agree on that definition? And then you can continue. All right, so already you almost had some trouble on the first couple of questions, and boom, you resolved it. So anticipate that. It's going to happen at some point to everybody. So just be ready for it, and that's how you can handle it. As you can see, the attorney continues on at line 21, and he's talking about a Citibank and says, I believe it's in Mineola on 2nd Street, but I don't have the exact address. Now, that's really a terrible way to begin the depo, because you're already showing that you don't even know what the hell you're talking about or where this place even is. How can that possibly be? You're empowering the witness, and unless you're doing this for strategic reasons, or if you're doing some kind of psyops deposition and you want the witness to think you don't know what you're doing, I get that, and I hear stories about that. But that's not my impression I get when I read this. Coming out of the gates on the deposition, the questioning attorney doesn't even know, where this, premises liability case, and that's what this is, this premises liability case, where it took place. And then you'll see something that should be a third rail for you guys who are training other lawyers. Defense counsel. All right, so this is plaintiff's counsel asking the questions. Now, defense counsel chimes in and gives the answer. It's like, are you kidding me? On the first couple of questions, you already, explained that you don't, and demonstrated that you don't know where this accident even took place. And now your opposing counsel is giving testimony on your deposition. It's unacceptable. And you have to stop that right at the get-go. All right. The best way to stop it is the best way to prevent it is just by asking proper questions. And you would have avoided. Anyway, let's continue on to see where this goes. We go on to the next page. That would be your next slide, and the top is 283, and you have page 6 of the actual depo. And the witness answers yes to the statement made by his own attorney. All right, that's a problem right there. Where's the control of this situation? It's already gone on, by the second page. So then the next question at line number 3 is, what is your actual title with Citibank? All right. Using the word actual is an invitation to trip up a questioning attorney. What is the difference between what is your title with Citibank and what is your actual title with Citibank? Do those phrases mean different things? I don't think that they do. Why would you use that? It's just filler. It's an amplifier of some sort. I don't know what it's there for. It serves no purpose and offers bait for for the opposing counsel to object to the question. And is there a form objection? Probably not, but it's just a bad question. You got to keep your questions nice and short, nice and tight, and clear. There's no reason to have that word. I know I'm nitpicking, but you'll see why as we develop, because this little this gaffe to me seems to snowball as we go through the deposition. So the question is, what is your actual title with Citibank? Branch manager is the answer. So the next question, I want you to think about this. Whether or not there is a form objection to this question. So if I was asking this question of your client, would you object to form and allow your client to answer over my objections? Here it comes. So you're the manager for the Citibank branch at 199 2nd Street. Do you object to form? Of course you object to form. All right, so let's say you have your form objection, but I really want the answer to this question. So I say to you, what is the basis of your objection, counselor? And the answer is, go to Marble Axe, you have the L for leading, and you have the A for assuming a fact, not an evidence. There's nothing in here that says that he was the manager at the 199 2nd Street. Go look at it. It's just not there. So you have a confusing situation already. But he answers yes. And then think about it again. Do you object to the form on this? Do you manage other banks? Do you object to the form to that? It's certainly objectionable. I mean, it's really confusing, because do you manage other banks? Is he asking whether they manage other branches or other actual banks, like TD Bank or some other banks? So I know it's nitpicking again, but there's no reason to be asking questions like this. It is the question and answer are not self-contained. But if you had gone through your quadrants that we had set up so clearly by going through the pedigree and finding out a little bit about their education and their employment history, and you want to know these things, because this could have been a brand new manager who didn't know what he was doing and had no idea how to take care of this place to keep it safe for customers. But if you had gone through your quadrant and you established all this, you wouldn't have had the need for opposing counsel to clarify later on, and you'd have some valuable information that you could use possibly for preparation or trial, or even the trial itself. All right, so the objection to form, they can answer over the objection. You see counsel here did not object because he realizes that there's nothing bad that's coming out to hurt him, nothing at all that can be used against him, so he's letting the attorney go on his merry way. If they had objected to every single question on here, the transcript would have been maybe 30 pages instead of 15, but it still would have been just as vacuous. So he did us a favor by not. But here we're observing the problems and they get worse. I promise you they do. So the answer is no. The answer is no, meaning that he doesn't manage other banks, but we don't know what he means by that. It doesn't matter. The answer is no. The next question: how long have you served in that capacity? Well, that question is not self-contained at all because we don't even know what that means or what the capacity is. We have no explanation of what a manager does, what his duties are, or what they're supposed to be doing, and how it relates to this case at all. So you have another form objection. How long have you served in that capacity? Objection to form. It's again, it's confusing. It's vague because we don't know what we're talking about. It fits in the Marvel Acts. If you're asked to give a basis for the objection, you have it, and it's not going to be permitted at trial. And and you could point out if it's used on a motion for summary judgment, you can object there as well, saying that you have objected to this and therefore it's not admissible. All right, and a little technical, but that's okay. We'll move along. So the answer to the question of have you served in that capacity, the answer is at that location since March of 2003. Okay, we have no information about, because he said that location, so that implies that there were other locations, right? Otherwise, he wouldn't have said that. So that should immediately, in your mind, should bracket out, okay, that location, where there are other locations, where were the locations, how long did you work there, and what were your duties at this place, how were they different from here? All right, and it just goes on and on and on. Okay, instead, we just move to the next, I guess, topic. The next question at line 15, objection or no objection? Here we go. In what legal manner, and I'm going to clarify this, is Citibank the entity situated in that property? Is it by lease? Do they own the property? Are you aware of the status? Objection or no objection? Technically, of course, you object to the form in your mind. I would let it sit there. Just let him keep going. What are the bases of this particular objection? Well, you have a bunch. It's calling for a conclusion. I mean, he's asking what legal manner? Are you kidding me? That's asking for right then and there. You know that the question is asking for a legal conclusion. It's confusing, right? That's your C under the Marvel Acts. It is multiple, which is the M in Marvel Acts, right? Because you're asking in what legal manner. Is it by lease or do they own the property? Are you aware of the status? I mean, you have multiple questions, and your multiple objection will be sustained if it's more than one, if you need that objection. But here the answer. Also, it's vague. So you have the B. So you have almost all the letters in your Scrabble Marvel Acts. So it's pretty cool. It's a really good question for purposes of demonstrating objections. The answer is lease we rent. All right. Where's the lease? Who knows where the lease is? There's just so many questions, and I'm not sure that even if you break down this question that you really need information that's in there. So it's just a question that just popped into the questioning attorney's head. It wouldn't formulate, so they kept going until they found a place to put a question mark. And the answer is lease we rent. All right, so you got something good. There's a lease. You're going to get a copy of the lease, and you're going to find out exactly who the signatories are, and you're going to get information like that. So you're going to get something, I guess. Because you know that they have a lease and they rent. The next question is, who is the property owner? Do we really? I mean, we know because we know we're in a lawsuit, and we know that the 199 Second Street, whatever it is, we've been talking about that. But who is the property owner is not self-contained, and it's vague because we don't know that. So you have another objection to form, and it's vague. They can answer over the objection, and their answer is, I don't know the actual corporate name. And here gives us a beautiful example of what to do with I don't know. What do you do with the witness who says, I don't know? Instead of exploring that, the questioning attorney goes on to line 24 and says, is there a check made out by your branch? Okay, forget about that. We'll talk about that in a second. But the I don't know, you can't leave alone. First of all, think about, what is it that they don't know? And also, if you notice that they use the word actual again, which may be a tick. Okay, so if you have that yourself, you have to get rid of that. You don't need. There's no difference between the corporate name and the actual corporate name. It's just not necessary. It invites a situation where they're saying, "What do you mean by actual?" And you have to go through the whole thing of taking out your dictionary or saying, "How do you use actual?" So it's just a big waste of time to put in those extra words in there. So how do you deal with the I don't know? You have to ask, well, who would know? Are there any records that would refresh your recollection or that you can make reference to determine who the actual owner, what the actual corporate name is? That's what you just can't leave it alone as an I don't know. All right, you have to get more. You have to find out where this information can be found. You can't just skip on, you can't accept the I don't know and hope you're going to, find out later who might know. So you have to really break that apart and find out, whether there's any emails or any pictures, any memos or any people that they could speak to that would make them be able to say, I don't know, but this person can get it for you, or you can get it by doing this. It's a deposition. You're allowed to ask normal questions, simple questions about where you can obtain information. Okay, so that's what you could do. All right. So I don't know the actual corporate names. Okay, going down to 24, objection or no objection. All right. So is there a check made out by your branch, or is that covered by a main office? Objection or no objection? I hope your vote was yes. Objection to form. What is the basis of your objection, counsel? Well, let me just check my Marvel Axe list here. Looks to me like it's vague, confusing, and multiple. You have two questions separated by or. So if you have more than one, it's multiple. So on that basis alone, your objection would be sustained. Is it vague? Well, what check is he talking about? And is the question confusing? Most questions that are multiple, not all, but most of them are confusing. So you've covered all your bases if you have made either one of those objections or all three of the questions. So it's a question that really should be recast and asked properly. So we go on to the next slide. And we're on page 7. On the top is 284. And the answer to the question about he only answers the second part of the question, which is covered by a main office, and the answer is covered by the main office. So the first part is not even answered. He did not get that. What did you learn by that? Covered by the answer, covered by the main office. Did you get any information at all? I don't think that you did. I really don't. And again, it shows you the importance of staying within your quadrant. Okay, even if you don't know how to phrase the questions properly, or if you feel too nervous to ask simple questions and you feel like you have to ask lawyerly questions, and the difference between regular questions and lawyerly are is that the regular questions you understand and the lawyerly ones you don't understand. At least you're in the right direction. At least you have a goal when you set up your quadrants. And and we're still really in the pedigree and talking about the history of the premises itself. So we're still in the early parts of the deposition. Next question on line 4 is there a way that you could find out the name of that landowner? All right, objection or no objection? I would say yes. The form is problematic. You have, because of the use of that landowner, and it's just vague. It's just confusing. And you're asking, is there a way that you could find out the name of the landowner? So the answer is Sal Jones. I mean, that's not responsive to the question. So technically, you also have an objection, not by the questioning attorney, that it's not responsive to my question. So there's a problem for both the attorney and for the witness here. And they say Sal Jones is the managing agent for our real estate, and they handle all matters regarding real estate on that. And you know what? There's just no development about. You just got a really important piece of information. You have a name, Sal Jones. Well, who is Sal Jones? Where does he work? What's his contact information? How do I get in touch with this person? What are his duties there? What is his position there? Okay. They named the managing agent, but exactly what do they manage? What does the managing agent? To your knowledge, what does a managing agent know? And and that's another thing. To your knowledge, and I'm sorry that I put that in there, but that's another thing that you shouldn't say in your questions, because you don't need it. It's baggage that's not necessary. It unnecessarily freights a very good simple question that you need an answer to. To your knowledge is not necessary. Okay, keep it out. Do you know? It should be taken out. Or if you know, this should be taken out. If your opposing counsel says if you know, then you have to object to that and mark the transcript for a ruling or for the court's attention on that, because that's a speaking objection, and it's improper verbal nudging is actually what it is, and it's inappropriate and sanctionable. And then you have on line 9, defense counsel again decides to chime in. Leave a space. This is the defense counsel. This is the person defending. Leave a space in the transcript so we'll ascertain the owner and put that in there. Okay, it's not horrible, But then our plaintiff questioning attorney says, great, that's my formal request. Again, we have that amplifier in there as formal request. I don't know what it does other than I guess it amplifies it, but unnecessarily. What's wrong with saying that's I adopt that request? Why didn't you even say anything at all? You have the lines in there, and you can see it physically. That's what the lines look like. And when they get a chance to read over the transcript, they're supposed to put that information in there. Which, by the way, you're going to see later on they actually did. Okay, so the next question, we have our lines there. So the next question on 18, were you the branch manager on or about March 4th, 2009? The on or about, you may want to lose that too. That sounds too lawyer. That's not conversational. That's not how we speak at Ammonia here on Broadway when we're speaking to one another, even with clients or whatever. On or about is an unnecessary legalism. It adds nothing to this, So you could just lose that. You'll be happy that you did. I know it feels good sometimes when you're saying it, but when you're reading it back, it's like, so try to keep it out of your vernacular. I promise you'll feel much better about yourself. Have way cooler transcripts, especially when you're reading this to the jury at trial, if that becomes necessary. So were you the compound question? Yeah, something, possibly, yeah, because you're saying on or back, when you have or in there, it's a red flag, you know what I mean? But the better objection, I think, and not to take away from that, Israel, is that it's repetitive, because this was already asked, a couple of pages ago. I know we're still very early on into the depot, but this information was already gleaned from them from, right at the beginning. So they're asking the same question again, which is repetitive. And, also because of that on or about, you've made it vague, and, it's just a poorly phrased question, and you don't want to do that. And if you follow your quadrant, with respect to pedigree and with respect to, the history of the company and the premises, this will be unnecessary. You'll have already established everything, and makes it easier for everybody. Granted, you'd have your transcript would be a lot heavier, compared to this, but it would be worth it, and you would have actually useful information, because as you'll see, the value of this entire transcript is nominal. And again, I'm not criticizing the questioning attorney. They just weren't prepared properly. Okay, they could be brilliant, and I sense in some of the questioning that there is brilliance under there somewhere. They just weren't prepared. Okay, and it's not to take away from them. It can happen to anybody. You go in unprepared, and you don't have a plan. This is what could happen. Okay, this is a casualty that we're going to learn from. So continuing on to line 24. And this, I'm sorry, I'm not laughing at the attorney, but do you have, this is out of the blue now, right? He answers, I do not recall. There's no follow-up on the do not recall about, what is it that you don't recall? Is there anything that would refresh your recollection? Are there any pictures? Are there any emails? Is there a diary? Is there a punch-in? There's a million questions you could ask them when they answered, I do not recall, because, all right, he could at least start by confirming that he was at work that day, right? I mean, how are you going to let him get away with, I don't know if I was at work or not? And then you're going to ask questions, later on about what happened at work, and you don't even know if he was there? Come on, man. Come on. All right. So line 24, do you object to this one or not, Israel? Do you have a punch card or anything like that where your schedule is set if you know where you were, if you were working that day? What do you say is, come on, object to the form, or are you going to let it go?
I think I would object to that.
I think you'd be sustained on that, buddy. and if pressed to state the basis of your objection, it would be multiple and confusing, obviously. Okay, you have many questions in there. And the answer to all those questions is no, we don't. But no, we don't what? I mean, which of those questions are they answering? Okay. When they say we, that is an invitation to ask about people other than themselves. All right. It's a little code. All right. If they're saying we, they mean themselves and somebody else, at least one other person. So you want to, flesh that out and find who's we, all right, and get the names and contact information and what they will be able to testify to, how they can help us with the case, with each of the person that constitutes we. All right, look, these are gifts from the witness. They want to talk, and our attorney wants to just ask crazy questions. So, all right, on line 5. This is like out of the blue. Is there a human resources director where if you need a day off, you would let them know, or is there a manner in which it is recorded? Stacy, are you with us?
Yes, I am.
Do you object to that one, or don't you?
I'm so sorry. Can you repeat one more time?
Yeah, the question? I will.
Yes.
All right, here's the question. Is there a human resources director where if you need a day off, you would let them know, or is there a manner in which it's recorded? Objection or no objection?
No objection.
You let it go.
What? I mean,
No. Is that your final answer?
Yes.
Okay, excellent. I mean, look, the defending attorney also let it go, Stace, and that's fine.
Okay.
And you'd be right to, because the answer cannot possibly hurt you on this thing. The answer was, there would be a manner in which it was recorded if I was off. Yes. That answer does not hurt you in any way. So it's okay that you decided not to object. But technically, is there an objection? Do you have the option to object? The answer is yes, because it's multiple. Look, it's number 1, is there human resources? And number 2, is there a manner in which it's recorded? That's 2 questions built into what they believe to be 1 question. So it's multiple, and you can object to the form, and it would be sustained. And if they said, state the basis for your objection, counselor, you would say it's multiple. All right, so that's how it is. That's how you would deal with that. And then they say there would be a manner. All right, remember that word. There would be a manner in which it was recorded if I was off. Yes. Well, that was another gift. Okay, manner. All right, because manner is a way. And what is the way? Explain the way. What is the process? What is the procedure? Who else knows about this? You have when they use a word like manner, it's an invitation to ask so many more questions. Like, explain manner. I want to know what the manner is in which it was recorded and where it's kept and who's responsible for keeping it and who's responsible for keeping it at the time of the accident and who's responsible for keeping it now. Is it kept anywhere else? Is it shared with anyone else? And on and on. And if you have your quadrant set up in front of you, just to make reference, you will ask those questions and you will fill in the blanks on those. So then, after the answer yes, plaintiff's counsel, our attorney at line 11 says, I'd ask by formal that the manner recorded be checked at the time of Mr. Singh's accident. All right, then defense counsel responds, leave a space in the transcript. That is not helpful at all. I think what plaintiff's counsel was getting at right here, instead of asking and exploring what manner is, what manner means, that he wants the witness to go back and check the way this was recorded without any, without any kind of foundation at all. So then what? Okay, so they go back and check. Then all right. So the witness goes back. He goes back to Citibank. He checks all his records, and he did exactly what the attorney said. The attorney didn't say to provide us with the information or provide it to your attorney. He just said go back and check it. You understand? So you have to be specific. Let's say he just wants to go back and review those records, see if there are any records, and provide them to your attorney, or advise them that these documents do not exist. You have to give them specific instructions if that's what you want them to do. But I promise you, if you follow your quadrant and you follow your plan, you won't even have to get into this stuff. All right? This stuff will be offered to you during your proper questioning. So we have more banter between plaintiff's counsel right after that. Defense counsel says, leave a space in the transcript. And the defense counsel says, I'm going to make some inquiries if you were working that day. That's defense counsel speaking now, not the questioning attorney. Why is this attorney talking? Why is the plaintiff's attorney allowing him to talk and give instructions? And more importantly, what is this about? I'm going to make some inquiries if you were working that day. So does that mean the attorney is going to go back to Citibank and make inquiries himself and determine whether or not this person was working there? Because really, you don't have that established in the record just yet, Or is the defense counsel going to ask questions of his own client later, and can they do that? The answer is that the defending attorney, so if my client is being deposed by another attorney and they're answering all their questions, and then the questioning attorney finishes, can I then ask my own witness questions? And the answer is absolutely yes, you can. And it's your responsibility to, if the record isn't fully developed, or if the record is vague, or if it could possibly be used against you, leaving it as is. So yes, and that's true under the federal rules of civil procedure, as well as the CPLR under 3113. Both of them say that the conduct of a deposition is in the same manner as a trial, and you were allowed to cross-examine at trial. So the answer is yes, and you can. But that's not what this attorney means. This attorney means he's actually going back to Citibank. But I just wanted to get that point in there. And if you'll notice that the witness had a chance to review it and filled in the blanks on the transcript. Isn't that cool? They actually, yes. And it says, yes, I would. And this is after we don't know until this document comes back to us, filled in by the witness, a month later. We don't know if he's actually working there after a deposition. And he says, yes, I was working on March 4th, 2009. Shouldn't that have been like a way at the beginning? I don't know. It'll be in your deposition. All right. And then we get to line 22. And the question is, do you recall on or about March 4th, 2009? Let me just stop there. You don't need do you recall, and you don't need on or about. You could just say on March 4th, did somebody come into the bank with an injury? Right? Instead, they ask, do you recall on or about March 4th, 2009, somebody coming into the bank with some type of injury or hearing that someone had slipped and fallen outside? Objection or no objection? Anybody want to take this? Anybody? Objection. Sustained. You have multiple, you have vague, and you have the A in the Marvel Act, which is assuming a fact not in evidence. All right? We have a fact in here that somebody was injured, that we haven't even talked about. We don't know anything about according to this trend, it's not anywhere in the record. So it's assuming a fact that's not yet in the record. Objection to form, sustained. You can answer over my objection. But, by the way, no one actually says sustained at a deposition. That's only at trial. All right. Attorneys can't sustain or overrule objections at the deposition, although some of my attorneys here have tried that just, to torture the opposing counsel. All right. The answer is I do not recall. When you get, see, before you might have been nervous about getting that as an answer. Now you should be excited about getting that I don't recall, because you're going to torture them. Come on. They came to a deposition. They got prepped by 5 corporate counsel on this thing 25 times, and they're going to say, I don't recall, and they think they're going to get away with that? Not with you guys. No way. So the next question on line 3 is, did you check any records to determine if there were any incident reports filed for that day? Okay, again, I understand what the attorney is trying to look for, but there's no foundation whatsoever on this thing. And the question in itself, just by itself, it's vague. It's assuming facts not in evidence. What incident reports? Do they have incident reports? Did you lay a foundation for whether this is the procedure, what happens when somebody gets into an accident, and was this the procedure that was in place at the time of the accident, that this accident took place? You need all that information. All right, you're not going to get it with questions like this. And the guy says, the witness says, I did not find any. That's amazing. This is a major bank, an international bank. If somebody gets hurt there and there's no record of it anywhere, come on, that's not true. And I don't think that the witness, I think that eventually if they were pressed, they would have given the right answers to this thing. So the next question on number 7, is it the standard procedure of Citibank that anytime there's an injury somewhere in the premises, it's documented? Objection to form? Yes, it is a form objection. First of all, it's not open-ended. Who, what, when, where, why? Those are the questions that you should be at. That's the form you should be using most of the time as the questioning attorney. And besides, this question is vague and it's also confusing. About at that anytime there's an injury somewhere in the premises, this accident happened outside, but does the premises constitute the entire land? It's confusing. All right, there's no reason to ask this question. There's a much simpler way. There's a way more Hemingway-esque way of phrasing the question on this thing rather than how it is. Okay, so object to form, you can answer over my objection. And he answers yes. Nothing is explored, no further information. And then we go to line 11, and it says that as long as you work there at the bank, what per day would you say, what is the amount of clients or people that come into the bank? Objection or no objection on that one? Anybody want to take a stab at it? Come on, Stacey, you're getting good at this.
Wait, Joe, can you repeat the question?
Yeah, here we go. You ready?
Yes.
As long as you worked there at the bank, what per day would you say, what is the amount of clients or people that come into the bank? Objection?
No objection.
No objection. Stacey lets it go. The answer is 250 to 450. Stacey was right, and the attorney who was on this also agreed with Stacey. But the objection is it's multiple. It's confusing. Are they asking for clients or for people? Does this include just clients, just people? And the answer is 250 to 450. But how is it that this person is able to give this information? How is that recorded? Who records such information? Do they have this written down somewhere? You can't just take that 250 to 450 and just leave it as it is. All right. The next question. Have you ever personally observed people using the teller driveway to walk up towards the entrance of the bank? Sounds a little confusing to me. Defending counsel did not object to it, but it's clearly a form objection. It's confusing. It's assuming facts not in evidence. What is a teller driveway? And And there's I mean, which entrance are they talking about? Is there only one entrance to the bank? Has that been established? No. So what information are you getting in this? Anyway, the answer is I've seen people walk through there where they were going. I don't know. We have an I don't know, guys. Bing. That's gold. Payday. Cha-ching. An I don't know. All right. So the next question is, have people ever tried to use the drive-through window without a vehicle? It's funny. It's a funny question. It's good. And they answer, yes to that question. And nothing further is developed from yes, but how he has this knowledge or when he's ever seen this happen before. And then then our questioning attorney says, what is the policy regarding that? It's an open-ended question. What is the policy regarding that? But unfortunately, we have a that in there, which means it's not a self-contained question. And you can easily remedy that is by first establishing that there is a policy, that a policy exists, and where it is, and how it is that they know about this policy, and who else knows about this policy, and then we get into what the policy is or says. All right, so you have a whole bunch of questions there. So that the objection to that question is a form one. It would be sustained. Answer over the objection. You have a foundation problem, and you have assuming facts not in evidence. So the form is definitely problematic on this. Defense counsel did not object to it, and rightfully so. They got nothing. We immediately inform them, pronoun. Remember what I said at the beginning? We immediately inform them that it's not safe. You really need to come into the branch. All right. So you want to establish the pronouns so that you can have information in there. Are you talking about clients? Are you talking about people that just walk by? Is this like is there an easement here where passersby just walk through? On Long Island, they have like situations like that, not so much here in the city, but these things do exist, but there's no clarification here. So you have no foundation on that. And then the next question, number 7, is, here it is. Is there somebody stationed at the driveway window throughout the day? The answer is no. I don't know. I guess they're looking to see if anybody would have been able to see what was happening out there. And I think that there's better ways to ask that. And you want to establish what they mean by the driveway window exactly. So I mean, a better way to handle this would be to have a chart, a diagram actually of the bank, how it's situated with the city, the streets and the blocks and the avenues and the buildings or whatever it is that's surrounding there, and and that you use that as a basis to solidify what parts of the bank that you're talking about, because here we don't know where it says. I mean, it makes mention of a driveway window, and the information that you got is a no, and what are the frequencies and time restraints? How about that question? What are the frequencies and time restraints? That is definitely a form objection. The reason is it's multiple, right? What are the frequencies and time restraints? Those are two different questions right there. So you have the multiple. You have confusing because you don't know what they're talking about frequencies. I guess you have to go back to the referent question and say, is somebody stationed throughout the driveway throughout the day? And nope, that doesn't answer your question. So you have to go back 2 questions to where it says, where the answer is informing them. So you have a lot of problems here with this, with getting information and putting it all together. It's really like a jigsaw puzzle and they're all the same color. Nothing's going to help you here. It's really not. What are the frequencies and time restraints? That question just has to be completely recast, broken down, and asked clearly. So the next question that we come to is, and let me just give what his answer is. Well, it's open 9 to 4, Monday, Tuesday, Wednesday, and 9 to 6 on Thursday and Friday. Then defense counsel chimes in at line 15, and they ask their own question to clarify. Is there somebody there all the time? Which, I mean, that's not really that helpful either. Where are they talking about? And you have to follow the bouncing ball here. And I lost the ball like 4 questions ago. So, I don't know what they are talking about. And then the witness responds to his attorney and says somebody is not physically standing there the entire hours of operation. No, there's a bell to ring for service. And then our attorney asks, do you know? Okay, try to lose that, guys. Do you know if there's any video cameras that capture transactions and movement in that area? Now, what happened there is that that the questioning attorney was not getting information that was helpful to them. Questioning attorney maybe realized there could have been, but just didn't know how to get it. So they changed gears and they went into whether, forget about people witnessing. Let's see if the cameras can witness. So they jumped over to the cameras. They skipped over a whole bunch of things and starts out saying, do you know if there's any video cameras that capture transactions and movement in that area? Well, that's a pretty confusing question, guys. That's a form objection. It's not self-contained. We don't know what it means unless we read everything all over again, plus read the complaint and probably get a map as well. We don't know. And they do give some information that there's an internal video camera towards the back of the teller and the window itself. Okay. The next question is, he begins again, and you see, I think they realize that they're having trouble at this point, that, just not even that deep into the depth, that they're just having trouble getting any information, and they start off with the do you know again, okay, which is bad practice. Do you know if that camera captures any images outside of the window? Answer, only what is directly in front of the window. How the hell do they know that what the camera captures? Did they review the film from the camera? Did they review the film from the camera on the day of this loss? Who else views the camera? What's the policy with respect to reviewing the films? Is there something that's done every day? Does anybody else do this? And what's done with the film after it's reviewed? I mean, you have a whole bunch of things, a whole bunch of information. And now remember, when we start with the question with do you know that if the camera captures any images outside of the window, the proper response is yes or no. Do you know if? The answer is yes or the answer is no. So the answer, only what is directly in front of the window, is not responsive. And if you move to strike is not responsive, at trial, that would be sustained. It's really not. So that's why you don't. I mean, that's not what they really wanted to know. They didn't want to know, do you know? They wanted to know if the camera captures. Do they have any knowledge of what the scope of the camera is, and whether there are any other cameras. So that's what happens again with a do you know on line 7. Do you know what the storage procedure is regarding any video footage captured? The answer is yes or no, but they give a non-responsive answer. I know it's electric or digital. I don't know the retention capacity or how long to retain. Where's the follow-up questions on that? Who knows these things? Where am I going to get the information that I need to prove my case, to show that you guys saw my client slip outside and no one did anything to help them? And that your people denied even knowing about that this accident took place. Where is this information? I don't know yet, so I don't know the answer to that. We're winding down now, okay, because I know this is not the easiest thing in the world. Coming down to line 19, the question is this. In other words, it's not a private agency or company outside of Citibank. It's Citibank's own employees. And what they're trying to do is find out the name of the security company. And you'll see they clung through. They get no information. All they find out is that they are employees of Citibank, but they don't know in what capacity they're employed. I mean, they could be independent contractors employed by Citibank, but there's no development of that. Okay. So we have a bunch of ways to go through this deposition transcript, and I see that our time is up for today. And I will continue a little bit more on this. Not much. I'm not going to spend too much time because this is really a tedious part, and you see why I called it a frog, because it's really, it's dead. It produced nothing, but we can learn from it by studying it. We cut it apart, and I don't believe that anybody would be able to determine who the questioning attorney is. It doesn't matter. They don't do this, they don't conduct depositions like this anymore. And, and I hope you learn from the mistakes that were made here, and I hope you understand a little bit better the process. You know, we're starting to come out of the quadrant now, and we're starting to really talk about asking better questions. And this goes for all of you, those of you who are doing intakes, those of you who are doing pre-sentence reports for us, and those are non-attorney positions that are putting those together. Prepping your client for their own deposition or for trial, asking better questions, and just in life asking better questions, you'll get clearer answers and get better information. And losing the lawyerisms, of on or before, or on or about, or question phraseology like that. You just get rid of it. You don't need it. Those are for non-litigation attorneys to use at cocktail parties. They're not for lawyers who are dealing with witnesses and juries and judges that are trying to get information conveyed from a witness to them. Okay, just so you know, this case turned out very well for the plaintiff. So in reality, the frog turned into a prince. And that's the end of our deposition training installment for today. And I'll see you guys next time. So are there any questions before we sign off on this? I'm sure there must be some questions.
Joe, sometimes when a question is asked and the witness answers too fast before you can object, can you then voice your objection after answer was posed?
Oh, yeah, and you object and you move to strike. Absolutely, yeah. And sometimes, and I do this at trial too. You ask a simple question, nice, it's under 10 words in there in the question, and the witness starts going off the reservation. I actually put my hand up and I say, I'm so sorry, I don't mean to step on your words, Mr. X. But my question was whether or not you knew, whether or not you had knowledge to where the documents are kept. If the answer is no, you don't know, you can just tell me that, and I won't bother you anymore with it. But you can actually stop them in the middle of the question, and that's okay to do. If you're opposing counsel, which happened to me one time before, I said allow them to finish the question, don't interrupt them again. Well, that's a troublemaker that you're dealing with, and I think you have to, be very polite and tell them that's an improper statement that you're making. I asked a simple question, and I'm going to get an answer to my question. That's why I'm here. So I'm not going to let him talk about whatever they want to talk about. They're going to answer my question, and if they don't, I'm going to stop them. I'm going to object, and I'm going to move to strike. And if you interrupt me again, I'm going to move for sanctions against you, and I don't want to do that. I like you, and I just want to get this deposition over with. So just let me ask my questions.
Thanks. And if you're defending the depo and it's your client who's answering and you want to object to that question, but he already answered, can you still object? So I want to object to form, but he answered it.
So as long as you objected and it's a proper objection, then the answer is not going to be used. So you'll be in good shape. Okay. The cat's already out of the bag, and competent counsel will address the objection and get you to state the basis and correct the question so that it will be an admissible form.
Thanks. And then the question of whether this witness was present at the bank that day was pretty important. I don't know if it's like a jerk move. Would it be improper? If I say, is there a way that your recollection can be refreshed? And you can say, I may have like text messages or a calendar, or like the manager of the bank would know. Would it be improper for me to say, let's take a 20-minute break so you can consult with the manager or look at your notes and then we will reconvene?
You know what? If you're the questioning attorney, you don't want it interrupted unless you're going to get some information that will be helpful to you. So, okay, so you're conducting the deposition. You control the deposition. You're the one who could say, do you mind if we go off the record for a moment, to your opposing counsel? All right. They cannot say, hold on one second, off the record. They do not have the authority to do that when you're conducting the deposition. You have the authority to say, no, I'd like to stay on the record right now. And then, you get them to say on the record, say, like, I think I have access to that information and like to take time out to get it for you. In that case, I'm saying, sure, let's go on, let's take a break. You know, in that case, or I'm going to say, let me finish my line of questioning. And at the break, you can go and you can call your back office, because especially you have a nice flow going. You know what I mean? But just keep in mind, if it's your deposition, you're asking the questions, you're the one who says on the record or off the record. Opposing counsel says off the record, you say, Bub, I'm not going off the record. All right, so you can make, and thinking in your head, so you can make some wise guy statements and make improper, statements or whatever it is. You're not allowing that. You want everything to be on the record, and you're not trying to be a jerk. You're just trying to protect yourself, and you just want to get the deposition over quickly. Once you have opposing counsel that wants to go off the record all the time and talk about things, you're wasting time and you're not getting information and you're getting distracted. And you don't want to be distracted because you got a plan. You got a quadrant set up, man. You have a goal for this deposition, and you're going to get in and you're going to get your info and you're going to get out. So don't let them take that away from you. All right, well, 5 minutes over. I'd like to thank especially Stacy for participating in our deposition training today. You did very well. Thank you. And thank you all for participating in this. I know it was a little bit dull, it was really a little bit technical going through the transcript. Read over the final pages on your own. We'll go over them quickly. If you have any questions or comments, we'll go over them next week, and I'll see you guys then. Thank you.